All right, hi everybody, I'm Paul Vacheski, NebraskaLandlord.com, and we're continuing the series of the different notices that are in the Nebraska Landlord Tenant Statute. And I wanted to talk about the 5-day notice for failure to deliver possession. It actually happens more common than you think, but the 5-day notice itself is not very common. So here, typical scenario is the landlord and the tenant, they sign a lease agreement. The tenant turns over the first month's rent and a deposit, and they're scheduled to move into the property, let's say April 1st. So April 1st comes around and the property isn't ready for whatever reason. All right, so the landlord is now in breach of the terms of the lease agreement. So the landlord tenant statute provides a couple of different options for the tenant, and I already have them on here on the board for you. So first of all, the notice is the 5-day notice for failure to deliver possession, the legal right of possession, and it's only exclusive to the tenant, meaning the tenant is the only person under the statute that can deliver this notice, and they're going to deliver it to the landlord or the property manager. It comes from Nebraska Revised Statute 76-1426, if you want to look it up. So let's take a look at this notice here, at least the requirements here. Number one, the property is not ready when it's supposed to be, as determined by the rental agreement, okay? The landlord, so the tenant kind of has a decision here. So if the tenant says, okay, I want to stay there, you're only saying it's going to be a couple of days, 2, 3, 4 days, whatever the case may be, and the tenant says, I still want the property, I'm willing to wait. Now, remember, the landlord's already collected usually the prepaid rent. Not always, but usually they do. In any event, the landlord must, and this isn't an option, the landlord must abate the rent, meaning for the number of days that the tenant does not have the legal right of possession, the landlord has to basically reimburse them for the rent or not charge them the rent. So if they've already given prepaid rent for the first month, then the landlord's going to have to give them that money back for the amount of days that's prorated that they weren't living in the property. Or if they haven't paid the rent, then they cannot charge them for those days that the property was not available or the tenant did not have legal right of possession. Does that make sense? Okay, so that's if the tenant wants to stay. If the tenant doesn't want to stay, which is their right, what they're going to have to do is give the landlord the 5-day notice. Now, remember what we talked about notices. The day that the tenant delivers the notice, hand delivers to the landlord or the property manager, or drops it in the mail, doesn't count, okay? That's called the day of service. So the tenant's going to deliver their landlord or property manager a 5-day notice. And the notice basically has to say, listen, you have 5 days to deliver the legal right of possession to me, or otherwise I'm going to terminate the lease agreement and move on. So let's say within this 5-day period right here, the landlord completes the work and turns it over. Okay? Well, a couple of things happen. First of all, the tenant must accept it. First of all, they must accept, they must move in. It becomes their property. They now have the legal right of possession. However, the landlord cannot charge them for those days that they weren't there. Okay, like we previously said. The other thing is to remember here that the property must be given to the tenant. So when the landlord transfers the legal right of possession to the tenant, they just can't do it to fulfill the term so they can get out of the 5-day notice. Okay, what I mean by that is the property has to be habitable, it has to be ready. So if they were doing some work, the property has to be completely and totally ready to go when they hand off the legal right of possession. That's an important distinction. They can't say, well, you know what, I'm going to turn it over and there's 2 rooms left or 3 rooms or 1 room left and I'll finish it as it goes so they can avoid their responsibility and try to get out of this 5-day notice. Again, that can happen. It has to be complete and whole. All right, so within that 5-day period, if the property is actually ready and they deliver possession to the tenant, then the tenant has to, under the statute, receive it. They can't say no, okay? Now, let's say that it goes past the 5 days and it's still not ready, then the tenant is the only one at this point that has the right to terminate the lease agreement. They can say, nope, we're done, And then at that point, they're legally not obligated under the terms of the contract because they can legally break it. And then the landlord is obligated to return any prepaid rents and security deposits, pet deposits, those type of things, rent, maybe they collected rent, any kind of rents and deposits that the landlord or property manager has already collected, they must return to the tenant that just terminated the lease agreement, okay? And here's the thing, we don't have punitive damages per se in Nebraska, but in the landlord-tenant statutes, it does provide for certain infractions in the statute that does allow for some type of punitive damages, and this is one of them. So the tenant could collect as much as 3 months rent and damages, or 3 times the actual damage, the financial damage that they suffered, i.e. maybe they had to get a hotel room, maybe they had to rent a different place at a higher rate, those type of things. So the tenant can either collect 3 months rent or 3 times of damages, whichever is greater, whichever is higher, and ask for reasonable attorney's fees. So that's the 5-day notice for failure to deliver possession. Again, it's not overly common, but it does happen from time to time, and the statute does provide for remedy should that happen. So, all right, let's move on to the next section.